Welcome to The Explainer. Today, we're diving straight into a fascinating, highly specific clinical scenario to unpack the absolute crux of patient autonomy, medical ethics, and healthcare law. You know, it's one thing to say you have a preference about your end-of-life care, but it's a completely different ballgame to understand how the massive, sprawling world of healthcare regulation actually enforces that preference. By breaking down the exact events of one patient's hospital admission, we're going to reveal the powerful legal mechanisms that protect our deepest, most personal healthcare choices. We've got a lot of fascinating, highly relevant ground to cover, so let's jump right in. We're starting our story with a very real, very specific case. Picture a 58-year-old man being admitted to the hospital. He's battling head and neck cancer, and right upon admission, he makes this profound, incredibly specific end-of-life choice. He tells his nurse, straight up, that he absolutely does not want parenteral nutritional therapy as his cancer progresses. I mean, really think about the emotional and clinical weight of that statement for a second. Here's a patient looking down the road at the trajectory of his illness, assessing his own core values, and actively stating what interventions he outright refuses to endure. He's not just passively sitting there receiving care. He's drawing a line in the sand and defining the boundaries of his treatment.
But here's the thing. It's one thing to verbalize a deeply personal preference to a single nurse during the chaos of a hospital admission, right? How does a patient actually guarantee this wish is honored down the line? How does a vulnerable person ensure his voice is legally heard and strictly respected by the entire medical team, especially if things take a turn and he can no longer advocate for himself? This right here is the ultimate question of bodily autonomy. It's the core dilemma of medical ethics. How do we bridge that gap between what a patient says today and what the medical system might actually do tomorrow? Well, when a patient speaks up like this, it triggers a very specific legally mandated protocol.
Section 1. Defining the medical terms. Okay, let's pump the brakes for a second and look at parenteral nutritional therapy. We really need to understand this strictly within the context of our scenario. For our 58-year-old patient, this is a specific advanced medical intervention. As his cancer progresses, this is the exact form of life-sustaining treatment he wants to avoid. He's making a definitive choice, prioritizing his own definition of quality of life over just prolonging the disease process. Grasping the sheer gravity of this clinical choice is absolutely crucial because it helps us understand exactly why legally protecting it matters so much.
And that brings us to the advanced directive. See, when the patient states his refusal, the nurse immediately responds by explaining that he can formally, legally specify these exact wishes by creating an advanced directive. This is the ultimate tool. It takes a fleeting verbal conversation and transforms it into a binding, recognized set of medical instructions that will follow him everywhere in the healthcare system. But get this. The nurse isn't just offering this up as some friendly advice. No, the nurse is fulfilling a highly regulated, mandated duty. The whole system is literally designed so that the second a patient expresses a boundary like this, they are handed the exact legal instrument required to enforce it.
Section 2. The 4 legal frameworks. So what's actually forcing the nurse's hand here? What legal framework requires them to provide this information upon admission? Let's look at 4 legislative and regulatory suspects derived straight from our case study. Which one dictates the nurse's actions? Is it the Patient Self-Determination Act, the Nursing Scope and Standards of Practice, the Patient Protection and Affordable Care Act, or maybe the Patient's Bill of Rights? Honestly, if you're standing in a hospital room, all of these sound like totally plausible guidelines for ethical care. But only one of them specifically mandates this exact exchange of information at the very moment a patient is admitted. It's like a giant puzzle. The trick here is to compare these options against each other. We have to weigh massive, sweeping healthcare laws against the specific, everyday professional standards of a nurse. Take the Patient Protection and Affordable Care Act, for example. That's a huge piece of federal legislation, mostly focused on insurance coverage and systemic financial reforms. It definitely doesn't dictate granular, admission-level clinical conversations. And the Patient's Bill of Rights? It outlines foundational expectations for ethical treatment, sure, but it lacks those specific procedural mandates. Then, on the flip side, you have the Nursing Scope and Standards of Practice, which govern day-to-day clinical competency. But remember, we're looking for a specific statutory requirement regarding the targeted delivery of advanced directive info.
Section 3. The governing law.
Okay, so having eliminated the broad systemic frameworks and the general practice guidelines, we are finally ready to reveal the exact legal mechanism at play. Let's trace the steps. Step 1, the patient's admission to the hospital. Step 2, his verbal refusal of the therapy. Step 3, the nurse's mandated response to explain advanced directives. The law we're looking for specifically triggers right at Step 1. It's the actual admission process itself that legally binds the facility to provide this information. Sure, the patient speaking up in Step 2 highlights the immediate need, but that legal requirement to offer the tool in Step 3, that was already activated the literal second he walked through those hospital doors.
And the correct answer is the Patient Self-Determination Act. This is the exact governing law. The nurse knows that the legal mandate to provide clients with info on advanced directives is cemented right here in this act. And just look at that title, self-determination. It's incredibly profound, right? The law explicitly recognizes that a patient's autonomy is paramount. It ensures that when our 58-year-old patient assesses his situation, the system is legally obligated to hand him the tools to protect his desires. Hospitals literally cannot keep patients in the dark about their right to refuse treatment. It forces the whole medical system to be proactive in empowering the patient's voice. As we wrap up this explainer, I want to leave you with one final, provocative thought, something that brings the clinical and legal weight of this man's journey directly into your own life. Because of the Patient Self-Determination Act, any hospital you walk into must offer you the information and the opportunity to legally document your medical choices. The legal mechanism is securely in place to protect your autonomy, just like it protected his. But here's the catch. The system can only protect the choices that you actually make and document. The tools are right there, but it's ultimately up to you to pick them up and use them. So, ask yourself, if you were admitted tomorrow, would your healthcare providers actually know your wishes?